Hello, greetings. Thank you to everyone for joining this event today on climate justice and the role of international law. My name is Emily Wilkinson. I'm a senior research fellow at ODI and head of the Resilient and Sustainable Islands Initiative, RESI. We are very excited to have you all with us and a fantastic agenda and speakers, and a reminder that we have simultaneous translation in Spanish, so you can select that option. But first, let me hand straight over to Sara Pantuliano, ODI's Chief Executive, who will provide some introductory remarks. Over to you, Sara.
Thank you very much, Emily, and welcome everyone to this online ODI event, Climate Justice and the Role of International Law. I think today's event comes at a very important time. The UN General Assembly will be voting shortly on a resolution led by the Pacific Island of Vanuatu, which is calling for an advisory opinion from the UN International Court of Justice, or ICJ, as it is called. If adopted, the resolution will ask the ICJ to clarify the obligations of states under international law to protect the climate system for present and future generations. But it will also clarify legal consequences for states that have caused significant harm to countries, to peoples, to individuals that are affected by climate change impacts. So I'm sure you all realize that this could be hugely important to advance climate justice. By clarifying state obligations in respect to climate change, this advisory opinion could help inform lawsuits around the world. It could potentially strengthen vulnerable countries' positions in international negotiations. So I think it's a really exciting time to be discussing the role of international law in climate justice. At ODI, we have long played a very active role in the climate arena. We provide policy-focused research and advice on climate-resilient economy transformation, on financing for resilience, on just transitions. And more recently, we've been supporting small island developing states to achieve financial sustainability and environmental justice. And we've been supporting international alliances and equitable societies through our Resilient and Sustainable Islands Initiative, or RESI, that Emily has just mentioned. So these are complex issues, but very urgent issues that require action at all scales and across all sectors. And on that, I'm really pleased to note that today's event includes a range of perspectives and speakers from many spheres. We have colleagues representing the legal sphere, human rights, climate policy, international development. It's the kind of diversity that we need to really push forward solutions. So I really hope that today's event provides a platform for a well-rounded, thought-provoking discussion on the current request for an ICJ advisory opinion, but also for other multilateral initiatives, as well as lessons for national climate litigations. And I hope that the experiences, the reflections that will be shared here today can go on to inform not just the UN General Assembly vote, but also the wider climate debate at COP28 and beyond. So I really wish you all an engaging discussion and productive event. I think there is a lot to learn from all of us. Back to you, Emily.
Thank you very much, Sara. So our event today, it will be split into two parts. First of all, we're going to be hearing from a number of high-level speakers to better contextualize the ICJ resolution and its importance. We're also going to have two panel discussions where we'll look beyond the current ICJ resolution to exchange views and share lessons from climate litigation cases and multilateral initiatives in pursuit of climate justice. So we're going to have a number of high-level speakers and two panel discussions to look at the national climate litigation examples and lessons from those, and the effect that international law can have on national climate litigation. And then we'll have a panel on the sort of more on the multilateral processes and dimensions of this. And hopefully we'll have time at the end for a Q&A and some closing remarks. But first of all, I'd like to hand over to our first invited speaker of the day, Nadia Sánchez Castillo-Winkles, who is an international lawyer at Climate Legal Consulting and also a visiting researcher at Utrecht University. Nadia, I hope you can set the scene by introducing the role of international law in advancing climate justice. Over to you.
Thank you, Emily. And greetings, everyone. I am delighted to give opening remarks on the role of international law in advancing climate justice. International law regulates action on climate change by setting its legal basis. Relevant international laws are, of course, the UN Framework Convention on Climate Change and the Paris Agreement, but also international human rights treaties and the UN Convention on the Law of the Sea, given the effects of climate change impacts on human rights and on the ocean. The international legal framework also provides relevant principles, such as international cooperation and the principle of prevention of significant harm to the environment. International law, it creates obligations for states. Our discussion today is ultimately about how to empower states to comply with these obligations. It is about how we can contribute to implementing international law relevant to climate change at the national, regional, and international level, using the rule of law to advance climate justice. One way of doing this is through turning to courts. I'd like to share a slide with you showing an overview of procedures requesting, I see it, requesting advisory opinions before international courts and tribunals. To date, 2 requests for an advisory opinion have been submitted. One to the International Tribunal for the Law of the Sea, and one to the Inter-American Court of Human Rights. At the same time, a multilateral process led by Vanuatu to request an advisory opinion of the International Court of Justice is ongoing among UN member states. The final draft resolution was uploaded to the UN e-delegate portal on the 20th of February, so 2 days ago. And states are now able to co-sponsor the resolution. The vote at the UN General Assembly is expected to take place in late March or early April. If adopted, the resolution will engage the International Court of Justice to give an advisory opinion to clarify the obligations of states in respect of climate change and the legal consequences for states where, in the light of these obligations, they have caused significant harm to the climate system and with respect to states, peoples, and individuals. In fact, what these 3 requests have in common is that they ask the respective international court to clarify state obligations. One of the roles of international law and the international legal system in advancing climate justice is therefore to make clear what action, climate action, states are legally bound to. In addition, advisory opinions carry significant legal weight and moral authority and can affect the judgments of regional and national courts. They can also guide public policy, as explicitly mentioned in the request by Chile and Colombia to the Inter-American Court. Importantly, the advisory opinions we are discussing today can also contribute to raising awareness about the international legal framework applicable to climate change and about the fact that climate change is a global challenge that falls within the international rule of law and not outside of it. You can stop showing this slide. Thank you. At the regional and national level, international human rights law is playing an important role in advancing climate justice. Currently, there are 3 climate cases pending before the Grand Chamber of the European Court of Human Rights. And hearings in 2 of these cases will be held in late March. In addition, the court has decided to adjourn its examination of 6 other climate cases until the Grand Chamber has ruled in those 3 cases that are pending. The European Convention on Human Rights has also been invoked in national cases, including the Urgenda and the Shell cases here in the Netherlands, the Klimatsa case in Belgium, and the climate litigation case in the Czech Republic. Human rights-based climate cases in Latin America have also referred to international human rights law in their legal argumentation, including the Demanda Generaciones Futuras versus Minambiente in Colombia, and the Demanda de Amparo Ambiental Álvarez y otros versus Peru. As a final remark, elements to take into account on the role of international law in national climate litigation include whether the national legal system incorporates international law directly, known as a monist system, or it requires an internal procedure in order to incorporate international law, known as a juris system. In many instances, however, a mixture of both a monist and a dualist approach applies depending on the nature of the international laws being considered. Notably, research shows that judicial attitudes are also a factor when it comes to implementing international law by national courts, and that national courts could act as agents of international legal development, including in the field of climate change. Thank you very much. Back to you, Emily.
Thanks a lot, Nadia, for explaining that and giving us a sense of the bigger picture and some of the kind of technical terms and processes. And I think I can speak for others who are not legal experts in saying that this is it's quite a complex area that we're trying to get our heads around, but really important for climate policy and development practitioners to begin to really understand what's going on here. So thank you for that introduction. Now we're going to get into a little bit more depth on some of the climate litigation that Nadia referred to, and I'd like to invite Cristián Delpiano Lira to speak. Dr. Delpiano Lira is attorney at law at the University of Diego Portales in Chile and has a PhD from the University of Salamanca, Spain, and is judge and president of the Second Environmental Court in Chile and vice president of the Chilean Society of International Law. Cristián, I hope you can give us an idea of progress in advancing climate justice through the Chilean courts. How far can climate litigation go? Over to you.
Thank you very much, Emily. Thank you very much to ODI for the invitation. It's a pleasure for me to share with you some thoughts and updates, really, about the climate justice and climate change litigation, especially in my country. I have just five or a little bit more, 6 minutes about to share with you some thoughts that it's going to be divided in 3 kind of screenshots that I would like to have regarding what's happening in my country, and what it is the context. It is developing the climate change litigation and the climate justice. And in the first place, I will talk about some words about the context and legal instruments regarding climate change in Chile. And the second, I'm going to share with you some examples about cases of that we have we have ruled in the Second Environmental Court, and the third in the third place, and very shortly, because Nadia told us about the advisory opinions. What is the context of these advisory opinions, and what in my thoughts is the importance of these advisory opinions from the International Tribunal of the Law of the Sea and the Inter-American Court of Human Rights, and eventually the ICJ advisory opinion that I hope is going to be in the future. Regarding the first thoughts, the context and legal instruments, Chile has been described as a highly vulnerable country to climate change, accomplishing 7 of 9 vulnerability characteristics as defined in the United Nations Framework of Climate Change Convention. And in this context, Chile has made serious efforts in order to count with a modern legal framework to face the effects of climate change. As a short review, I will remark 2 instruments. The first is a green tax law, which went into force in 2017, regarding mainly emissions of carbon dioxide, sulfur dioxide, and nitrogen oxides, regarding greenhouse gases, from stationary sources with boilers and turbines, and attacks on the first sale of new cars, considering the expected nitrogen oxides emissions over their lifetime. In June 2022, 6 months ago, came into force the Framework Law on Climate Change, the Framework Law I will call hereafter, which represent, in my view, a whole new paradigm in the lawmaking process in our country. This Framework Law was built upon international recommendations and the principles of, among others, scientific validity, cost effectiveness, ecosystem approach, precautionary principles, citizen participation. I mean, principles that has been developed strongly in international law, and much of them born in international law. So here is a first point about the importance of those advisory opinions and the evolution of these principles in international law for the judicial application in internal courts in general, and in particular in the Second Environmental Court. The Framework Law focuses in three main topics. The first is a multi-level governance from national to local authorities, including public and private participants in this governance. The second is the several environmental management tools, some of them subject in the future to the judicial revision before the environmental courts. As I said before, this law has 6 months, and these instruments are building now. And the third is that the projects or activities submitted to environmental impact assessment shall consider the climate change variable in the environmental components according to the respective regulations to be issued by the Ministry of Environment, which was recently released. In the second point, the Chilean case law, in Chile, as in many other countries, climate litigation is increasingly viewed by plaintiffs as a tool to reverse environmental decision or to repair environmental damages. In this regard, the Chilean environmental courts have had the opportunity to solve legal disputes on which climate change has been a critical element on the debate as well as on the judicial decision. I'm going to share just one slide to show you. I think it's going. You can you see the slide?
Yes.
Yes. Thank you. If we consider the Savings Center for Climate Change Law database on climate change that I'm showing you in the slide. This database on climate change litigation, it says you have several here topics about the climate change litigation. In Chile, we have most of our cases has been situated on environmental assessment and permitting, as you can see in the slide, and suits against corporations. As a result, we have about 10 or 12, more or less. It's a breaking news. We are receiving now some other cases that we're going to analyze. So we can find some examples of climate change criteria on Chilean judgments, even if its developments in the judiciary practice is still in early state. Among those examples, I would like to share with you 2 cases in order to fit the time. The first case is Compañía Minera Nevada S.p.A. Against Environmental versus Environmental Assessment Agency. The case regarding a mining project, Pascualama, it was about the revision of an environmental authorization of a mining project in operation at that time. The mine is closed now. Based on changes produced on assessed variables, especially water quality. In this case, the Environmental Court ruled that the objective of the procedure established on the revision of previous authorizations, environmental authorizations, is to take corrective actions to adapt a project that was assessed in the past to any type of natural or non-natural phenomena as a tool to prevent risks to the environment. Among those phenomena, the consideration of climate change and its associated risks was crucial for the court and must be included in the review process of the environmental authorization. Then the second case, called Jara Alarcón versus Environmental Assessment Agency, about a different mining project in the northern part of Chile, called Cerro Colorado. In this case, plaintiffs challenged the environmental impact assessment for the continuation of a mining project in the Tarapacá region of Chile. The main claim refers to the lack of due consideration of public participation on the mining project's impact on groundwater resources and related surface ecosystems. The court did not question the methodology for evaluating the impact on water resources, nor did it annul the mitigation measures originally imposed within the evaluation process. Quite the opposite. It considered that these measures were aligned with the relevant norms. However, the court considered that a proper approach, taking into account the country's international commitments under the United Nations Framework on Climate Change Convention and the Paris Agreement, also requires the incorporation of climate change scenarios. Thus, it requires reassessing the mitigation measures regarding the extraction of groundwater resources in the area in light of current and potential climate change impacts. Then, as a third topic I would like to share with you shortly, is about the impacts of this advisory opinions of international courts, or where are we going with this advisory opinion. For Chilean environmental courts, the decisions of international courts upon requests of advisory opinions are greatly welcomed as sources of new criteria and interpretations regarding rules and principles of international law related with climate change justice. Those opinions will be, for sure, considered as a part of the framework to solve the increasing number of cases on climate change litigation. Nowadays, we have, I will not refer to the request eventually the request for advisory opinion on the ICJ, but it is important to say that we have the request on the International Tribunal of the Law of the Sea and the Inter-American Court of Human Rights. As Nadia said before, at the end of 2022, Chile and Colombia signed a request to the Inter-American Court of Human Rights for an advisory opinion on climate change and human rights. The request is related to the human rights obligations of states at national level, subnational entities, and non-state actors facing the climate emergency. The advisory opinion request will guide the countries of the region for the development of policies and programs at the local, national, and international level that uphold the commitments under the American Convention on Human Rights and other human rights and environmental treaties. But also, it will be useful for other countries abroad, the inter-American system, considering universal principles of human rights and the principles of environmental law and climate change law as well. So, as final remarks, and as a short resume, I can highlight the following topics. The first, Chile counts with a framework law on climate change and other technical regulations. Together, they constitute a regulatory framework that must be obeyed by public and private actors that opens new challenges for future litigations in our second environmental court. The second remark is that Chile's environmental courts have ruled on legal disputes in which climate change was a critical factor from legal and scientific point of view. This is going to be a good basis in order to see or to evolve the rules and interpretation of rules and principles regarding climate change litigation. And third, and finally, in a breaking news context, really, to quote advisory opinions request will be an important source of new criteria for climate change litigation cases settled before the Chilean environmental courts. Thank you very much again, and I'm open to Q&A, to questions afterwards. Thank you very much.
Thank you so much, Cristián. And yeah, I'm sure people will have questions they'd like to ask you. You can put them in the chat. That is really fascinating. I think I'm really stunned by the amount of cases that there are going on. And I think, really the fact that, those are originating in Chile and Latin America and many other places is really very promising and when one of those cases is successful, that will really create an important precedent. I want to move on to our first panel discussion, which will look at the synergies between climate justice and litigation and international law in a bit more detail. And to understand the importance of the ICJ resolution, we really do need to be clear about these links between international law and national climate litigation, how they influence each other. So I have two panelists here today who have both practiced law and are specialists in human rights law. Rohan Nanthakumar is a senior solicitor in the Pasifika Program, which is part of Australia's Environmental Defenders Office. And Rohan focuses on clement and environmental justice litigation, particularly in Fiji, Papua New Guinea, Vanuatu, and the Solomon Islands. And the other panelist is James Goldston, who is Executive Director of the Open Society Justice Initiative, which advances the rule of law and legal protection of rights around the world through advocacy, litigation, research, and the promotion of legal capacity. So let me start with you, Rohan, ask, how do you think international law can influence national climate litigation? And if you can give some examples from climate litigation cases of interest that you're aware of, that would be great.
Sure, thank you, Emily. And hi, everyone, and welcome. I'm speaking to you today from Naarm, or Melbourne, in Australia. And I just very quickly want to pay my respects to the traditional owners of the land on which I'm speaking from today, which is the Wurundjeri people of the Kulin Nation, and pay my respects to the elders, past, present, and emerging. So, good question. How does international law influence national climate litigation? So I think at the outset, it's helpful just to zoom out for a minute and just appreciate that what we're seeing at the moment is a dialogue amongst courts of the world as they sort of reason toward, one case at a time, a principled position on the law of climate change, essentially. And that dialogue is very much informed by international law. Any advisory opinion that we get will be critical in informing that dialogue. But that dialogue fits into a feedback loop where national climate litigation, also as a source of law for the purposes of the International Court of Justice statute, can also have an influence on international law making in that court. And so there is that feedback loop that happens. One busy, I guess, manifestation of this dialogue is happening in the field of human rights and climate change, or human rights and the environment generally. International law has for a long time recognised the link between human rights and the environment. It sort of started off as a kind of greening of existing human rights law, whereby instruments and courts would start to recognise that existing human rights have a particular environmental content that can be used to protect against environmental degradation and climate change impacts. And then more recently, you're starting to see the growth of a sort of autonomous, specifically environmental right, like a right to a healthy environment or a right to a clean environment. And there are numerous instruments that have been critical in that story. So you have the Inter-American Code of Human Rights' advisory opinion of 2017 on human rights and the environment, which is highly influential. You have Human Rights Committee General Comment number 36 about the right to life, recognising the link with climate. You have more recently UN Human Rights Council resolutions and UN General Assembly resolutions recognise the right to a healthy environment. And most recently, you've got a UN Human Rights Committee decision or view called Illy and others against Australia, or also called the Torres Strait 8 case, where the committee upheld that Australia had violated Torres Strait Islander claimants' rights to culture and also to private family and home life, although they appreciated that climate change impacts on the Torres Strait Islander communities could impact or violate the right to life because of the factual basis on which the case was brought. The committee ultimately wasn't comfortable with saying a violation had in fact occurred with respect to that right. So I set out those international examples really for this purpose. They get picked up and utilised down at the domestic level. The extent to which that happens can vary. So if I do a lot of work in the Pacific, and a lot of Pacific constitutions have provisions that authorise the courts to look at international law when they're interpreting and applying the rights that are contained in their constitution. And so in that kind of scenario, those kinds of instruments are very helpful, and it's not very controversial for those courts to use them. So there's a case called Morawa and China Harbour Engineering Company, which was held in 2020, where Justice Kandakasi of the PNG National Court, probably the greenest judge of that court, extended or developed the right to life in the Papua New Guinea Constitution in line with international law to recognise its environmental and climate related content. However, sometimes it's not so easy. So, for example, in my country, Australia, we have a bit of a degree of caution when it comes to our courts engaging with international law materials and foreign law materials. But even in that setting, it's generally accepted that international human rights law can be an interpretive source for determining the scope and content of rights. And so in a recent case called, just late last year, called Waratah Coal and Youth Verdict, the Land Court of Queensland was authorised to make a non-binding recommendation to a minister not to approve a coal mining project on numerous bases, including the unjustifiable impact that would have on the human rights of the communities affected. And in so doing, acknowledging the caution that every Australian judge seems to have to say, they went on to consider the Inter-American Advisory Opinion on Human Rights and the Environment to help recognise the link between human rights, environment and development. And then they also went on to recognise, to use that very recent Human Rights Committee decision, Billy, that I mentioned, to help give scope and content to domestic human rights that are essentially implementations of Australia's international human rights law obligations. So those are just two examples of the influence international law can have domestically.
Thanks very much. Fascinating, Rohan. And I think, fascinating that there have been successful cases. So not just things underway, but cases that have actually had an impact already. Let me turn to James. Same question, really. Do you have examples where you can see that international law is having an influence on national climate litigation, and how do you see that progressing?
Thank you, Emily. And I want to thank ODI for this event, which I think is really important. And I also just want to do a shout out for Vanuatu for its courage and leadership and skill in marshalling a coalition that puts this issue front and center, potentially before the International Court of Justice. I think that's hugely significant. I think the question of how international law influences any national litigation is, of course, complicated, and as we've heard from Nadia initially, can depend on a number of factors, including the nature of a country's judicial system, its judicial culture, the weight that international law carries in domestic law, the particular topic at hand, and of course, by virtue of their procedural posture, some cases may be more susceptible to the influence of international law than others. But in general, we've seen that international law has played an increased significance in the reasoning of national courts considering climate changes in the last several years. In 2018, the Colombian Supreme Court, as we heard, recognized the Colombian Amazon itself as a subject of rights entitled to protection, conservation, maintenance, and restoration. The court ordered the government to formulate and implement action plans to address deforestation in the Amazon. And in so doing, the court relied in part on international legal norms, including the Framework Convention, the Paris Agreement, the Aarhus Convention, which together, of course, establish the right to a healthy environment, require states to take action to mitigate climate change, and ensure public participation in decision-making related to the environment. The court also recognized the precautionary principle of international law, requiring that states take action to prevent environmental harm, even in the absence of complete scientific certainty. And the court's decision recognizes international law norms are binding on the Colombian government and play a critical role in defining the government's obligations with regard to the protection of the environment. In 2021, the German Constitutional Court, in the Neubauer case, struck down parts of the Federal Climate Protection Act as incompatible with fundamental rights for failing to set sufficient provision for emission cuts beyond 2030. And for the first time in its jurisprudence, the court stated that the fundamental rights as intertemporal guarantees of freedom afford protection against the greenhouse gas reduction burdens imposed by German law being unilaterally offloaded onto the future. As in Colombia, the German court relied extensively on international law. The court noted that Germany, as a signatory and ratifier of the Paris Agreement and other international treaties and agreements, has legal obligations under international law to take action to mitigate climate change and limit global warming. The same year, 2021, in Milieu Defensie versus Shell, the Hague District Court in the Netherlands found that international law imposed legal obligations on a private corporation and ordered Shell to reduce its emissions by 45% by 2030 relative to 2019 across all activities, including its own emissions and end-use emissions. And in reaching this path-breaking decision, the court made extensive reference to the Paris Agreement, the UN Guiding Principles on Business and Human Rights, the Universal Declaration of Human Rights, and customary international law. The court held that Shell's duty to reduce its emissions was derived both from Dutch law and international law. And then in 2022, most recently, in ordering the Brazilian government to fully reactivate its national climate fund to support projects that mitigate climate change, Brazil's Supreme Court recognized the Paris Agreement as a human rights treaty, which gives it legal significance for future cases. Treaties on environmental law, the court reasoned, are a type of human rights treaty, and for that reason enjoy supranational status. There is therefore no legally valid option to simply fail to combat climate change. So in brief, those are just examples, but international law, I think it's fair to say, is gaining more frequent reference in national litigation with increasingly meaningful impacts on the jurisprudence. Thank you.
Thanks a lot. And yeah, I mean, I think, again, perhaps participants in this call will not be aware really of the significance of those cases and the sheer number of them. So I think this is a really important discussion. I want to move into the sort of the implications of this increasing amount of climate litigation and national frameworks, legal frameworks that's developing. How do you think this is going to influence international climate change commitments? Do you think that these kind of the sort of legal processes are going to have an influence or a bearing on the climate change negotiations? James and then Rohan.
Sure. Thanks again, Emily. And just to be brief, in thinking about the impacts that litigation can have in terms of compliance with international climate change commitments, there's, more generally an abundant literature on the impacts of strategic litigation. Academic studies have come to different conclusions about the extent to which governments comply with court judgments and why they may do so. In fact, my organization, the Open Society Justice Initiative, has published a series of reports based on extensive research examining the many different impacts that litigation can have in different fields. But in examining how litigation can influence compliance with international climate change commitments, let me limit myself to 4 points. First of all, I think litigation can create legal precedent and clarify the legal obligations of countries and corporations to reduce greenhouse gas emissions and comply with international agreements. We've seen that in the Urgenda case in the Netherlands that was referred to. We've seen that ultimately in the subsequent Royal Dutch Shell case that established a legal precedent that corporations can be held accountable for their role in contributing to climate change and can be required to take action to reduce their emissions. These were both domestic judgments. I think the Vanuatu initiative may be even more consequential in asking the International Court of Justice expressly to examine what are the legal obligations of states flowing in part from their existing climate change commitments. And the parallel COSIS initiative before the International Tribunal on the Law of the Sea also, I think, could be potentially highly significant. Secondly, litigation can shift the policy or practice of governments or businesses. In the Neubauer case in Germany, for example, just weeks after the court upheld the claim by youth plaintiffs challenging the constitutionality of provisions of the German climate protection law, the German cabinet took action. It approved proposals to raise their climate mitigation targets to net zero greenhouse gas emissions by 2045, with targets to reduce emissions by 65% by 2030. And following the Hague District Court's decisions in the Shell case, and even while that case is now on appeal, Shell nonetheless announced its intention to increase the speed of its planned transition to cleaner energy production in line with the judgment. And after the ruling in that Hague case, the Financial Times quoted representatives of other businesses in high-emitting industries as confirming that they too will be increasing their climate change mitigation efforts. Third, in addition to making precedent and changing policy, litigation can impose financial costs and reputational harm on entities that are not complying with their climate change commitments, which may incentivize them to take actions to reduce emissions. Several municipal governments in the United States have filed lawsuits against fossil fuel companies, arguing that the companies should be held liable for the costs of adapting to rising sea levels and other climate change impacts. These lawsuits seek to impose financial penalties on companies and raise awareness about the role of the fossil fuel industry in contributing to climate change. And so as they proceed, they may have indirect impacts on company share prices that we may see. In another case, in 2019, a Scottish court ruled that the Royal Bank of Scotland had failed to adequately consider the climate change impacts of its investments and ordered it to review its policies. That ruling imposed reputational harm on the Royal Bank and highlighted the need for financial institutions to take climate change risks into account. And finally, a fourth element, I think, is that lawsuits can build public pressure about the importance of complying with international climate change commitments. In confirming the obligations of governments to comply with national and international climate change commitments, we've seen that the decisions in Colombia and Brazil help galvanize public pressure and raised awareness. Indeed, sometimes even the mere filing of a lawsuit can act as a focal point for public attention on climate change before a ruling is issued. And we've seen that development with the landmark legal action by a Peruvian farmer against the large German electric company, RWE, which was filed in 2015 in the court in Essen, Germany, and is currently pending, but has already raised a great deal of attention about what RWE and other similar companies are doing. Let me stop there.
Thanks very much. And yeah, really highlighting the kind of implications, particularly for the corporate sector. I wonder, Rohan, are we also going to see governments kind of stepping up their commitments? Are we going to see sort of more interest in advancing like the support to loss and damage and these kind of discussions in the climate change negotiations as a result of this pressure coming around climate litigation and sort of the legal issues?
Yeah, broadly, I think so. Broadly, I would endorse everything James, the 4 points that James has made about how litigation, allows the enforcement of commitments on governments and on occasion also on private entities, that it can change policy, that it increases reputational risk and can impose financial penalties and that it builds public pressure. Those I endorse that entirely. The one I might just zone in on the first point, that the enforcing of commitments. When you zoom in, that picture can sometimes be a little bit obscured for reasons that have already been mentioned. So at a granular analysis, how influential litigation can really be can will vary. It'll depend on the type of court you're in, the constitutional role of that court in the context of its constitutional system and design. It will depend on the particular cause of action that's invoked to try and enforce the climate change commitments, be it tort, be it human rights law, be it administrative law, be it something else. And then to pick up on, we'll be inspired by Nadia's point before about appreciating the difference between monism and dualism. It'll also depend on whether these international climate change commitments, at least in some states, have been implemented at the level of law as legislation, or whether it's still at the level of policy. So courts are quite comfortable coming in and arbitrating issues or adjudicating issues at the level of law. They feel they've got the institutional competence to do that, and they've got the constitutional authorization to do that. But at the level of policy, it can be more tricky. Courts don't feel necessarily like they have the institutional competence to do that or the constitutional authorization to do that. And if I can just very quickly give a couple of examples sort of making that point good. So the first is a New Zealand example called from a case called Smith and Fonterra. So Mr. Smith, who's a Maori man, on behalf of himself and his community, brought a case against Fonterra and other entities in relation to their emissions and really their inadequate offsetting. So the broad point was that you guys aren't going to reach net zero in the time you have to. And they chose tort law as the vehicle to bring that claim. And the court threw it out. They struck it out at the beginning without even, well, they dealt with the tort questions, but in a sort of non-binding way. We call it obiter dictum in at least common law countries. It's sort of just some reasoning that the court gives, but it's not binding reasoning. The binding reason why they threw it out is really because they said that kind of assessment is not one that tort law, as applied by a domestic court, is well placed to make. That they said that what you need to assess whether this company is adequately offsetting is a sophisticated regulatory response that is established in law and that has been benefited, I guess, from the product of international coordination. So that's them essentially saying, if it's not in law, we're not going to go there, and you can't use the common law tort of negligence to get us there. That's not our role. So that's one example. An example on the other end is that case I mentioned before, Waratah Coal, where because of particular legislation in Queensland, the court was authorised to make non-binding recommendations to the minister about whether or not that minister should or should not approve a coal mining project. And I mentioned before how part of the reason why the court said, no, minister, you shouldn't approve this mining project because of the impact it would have on human rights. Another factor that the court considered was that the project itself would make a material contribution to climate change, and critically, it would narrow Australia's options for achieving Paris Agreement goals, for achieving its international climate change commitments. And that's significant because that's the court saying this might actually constrain Australia's ability to meet its international climate change commitments, and so the minister shouldn't approve the project. That's the court getting into the policy question, yeah? Not the legal question, the policy question. But the only reason that it's doing that is because it has been authorised to do it in a non-binding way by way of recommendation. And so those fears that at least a common law court often has about its institutional competence and its constitutional authorization, they start to fall away, and the court becomes more comfortable in trying to hold the government to account about its climate change commitments.
Thanks. Thank you very much. Those are really excellent, very kind of vivid examples. We're going to have to move on. I suggest if you have some good kind of publications, further information, James and Rohan, on these topics, if you could put links in the chat for people to follow up, that would be great. We're going to move on now and welcome His Excellency Ralph Regenvanu, who is Vanuatu's Minister of Climate Change Adaptation, Meteorology, Geo-Hazards, Energy, Environment and Disaster Risk Management. And the Minister is, because it's very late in the evening in Vanuatu, has kindly recorded a speech for this event. So I think if the team could please play the speech, the Minister is going to talk a bit more about the ICJ initiative and its the purpose and why many other nations are really getting behind this initiative. So I think if we have the video ready to play. Thank you.
Good morning. I'm very pleased to be joining you today to discuss a very timely topic for my country. The planet is facing an existential climate crisis. This is not in dispute and has not been for some time. The science is clear. 7 years ago, 196 parties at COP21 in Paris signed a legally binding international treaty on climate change. Countries around the world celebrated this landmark first step to what we hoped would be accountable, transparent, and life-saving requirements to reduce the impact of global warming. But unfortunately, little has changed, and those most vulnerable in our small island developing states knew something more had to be done. Beyond the UNFCCC, other instruments under agreed international law already contain clear obligations to prevent harm to the environment and protect human rights. But how can these obligations be applied to the climate crisis? Pacific Island University students asked themselves and others these questions. Those discussions grew into a truly international call for clarity and for justice. Vanuatu accepted the call from our youth and has since been leading the campaign for an advisory opinion on climate change from the International Court of Justice. The ICJ is the only principal organ of the UN system that has not yet been given an opportunity to help address the climate crisis. To get to the court, next month Vanuatu and 15 other nations will table a resolution at the United Nations General Assembly. If we obtain a simple majority of votes in support of the resolution, the International Court of Justice will consider our question. Right now, we have around 90 countries that have confirmed they will vote in favour of this UNGA resolution, so we are nearly there. But more needs to be done. Specifically, we need to ensure all member states feel comfortable that this initiative is not intended to name or shame any particular nation. The question to the court only asks for clarification of legal obligations already agreed under international law and does not create anything new. The question is also forward-looking, considering both historical emissions, but also emissions of today and the future. The primary goal of this exercise is to bring clarity to all states so that we can take better action moving forward. The resulting advisory opinion will help states revise and enhance their nationally determined contributions under the Paris Agreement and strengthen domestic laws and policies. The advisory opinion will likely identify gaps in international law, which will help us as we build and improve our multilateral climate negotiations processes. The advisory opinion will also ensure we base our relationships on the adherence to the rule of international law. As we have seen with the recent destabilizing war in Ukraine, we must prioritize an international legal framework which is clear on what acceptable state behavior is and what is not. The rule of law is foundational to the United Nations and to its mission of peace. From the smallest villages in the Pacific Islands to the global stage, the rule of law is all that stands between peace and stability and a climate-safe world and utter destruction. The rule of law protects the vulnerable and is the basis of international cooperation, especially in regards to climate change. Vanuatu has heard the strong call and expectation from grassroots youth movements and indeed over 1,500 civil society organizations from around the world to draft a forward-looking, indeed intergenerational question. Colleagues, the focus of the question is on the protection of fundamental human rights of present and future generations, a critical shift in narrative which may yield greater climate action and ambition among all states in the global community. In conclusion, it is time for the world's highest court to give us the clarity we all need to do more. We are out of time in Vanuatu, and our children need us to demonstrate the required leadership. Friends, not all states are of the same opinion as Vanuatu on the value of this initiative. But you can sway their view in the next weeks before the vote, and I ask you to do all you can in this regard. Thank you for your attention.
So a very powerful speech from Minister Regenvanu there makes it clear how much is at stake and how important this advisory opinion really is to Vanuatu and other small island developing states and other and developing countries and the world. So our second panel discussion will look at the role of the international courts in climate justice more broadly and how they sit within the overall climate change and policy architecture. This panel is going to be moderated by my colleague Christopher Bartlett, who is Climate Diplomacy Manager for the Republic of Vanuatu. Christopher, over to you. And we have until about 20 past the hour for this panel discussion. Thanks.
Thank you very much, Emily, and thank you to ODI for organizing this very useful and timely discussion. As you've heard from the Honorable Minister, the increasingly devastating impacts of climate change are existential for the Pacific Islands, and there is a need not only to address the impacts themselves, but also the injustice that brought us here in the first place. Just days ago, as we heard, the core group of 18 nations have finalized and uploaded the final draft resolution, which will go before the United Nations General Assembly next month. And countries can now become co-sponsors of this resolution. And in fact, just over the last 2 days, we've had more than 24 countries officially register to be co-sponsors of this resolution. You can actually read the resolution right now on the website of the Vanuatu government, which is vanuatuicj.com. And you can see just how transformative the question is. What it does, it asks two very straightforward questions under international law. The first is, what are those legal obligations of states? And the second, of course, the legal consequences when significant harm results. And I'm very pleased today to introduce you to 3 incredible panelists who will react to this initiative on an advisory opinion from the ICJ from their own context. We have Digno Montalván, who is a researcher at the Universidad Carlos III in Madrid. We have Nicole Ponce, who is the front convener for Asia of the World's Youth for Climate Justice, and Harjeet Singh, who is the head of Global Political Strategy at Climate Action Network International, as well as the Global Engagement Director of the Fossil Fuel Treaty Initiative. But first, over to you, Digno. He will be responding in Spanish, so please do ensure you're on the correct channel for interpretations. But Digno, could you tell us more about the innovative request that has recently been brought by Chile and Colombia for the advisory opinion from the Inter-American Court of Human Rights, and how this, as well as the ICJ advisory opinion process, can actually move us forward towards more ambition in climate action. Over to you, Digno.
Thank you very much, Christopher. Thank you very much for the organization of this panel. Muchas gracias por la invitación y muchas gracias.
Thank you very much for the invitation, and thank you for this introduction. I would like to highlight the specific aspects of this opinion in relation with the obligations that the states have in climate.
Los impactos diferenciales.
It's important to highlight the different impacts that this is having in different countries in Latin America. In 2022, in March, the Inter-American Human Rights Commission was highlighting in his report, the report highlighted the importance for the states to ensure the mitigation of this environmental impact due to the climate crisis, especially in the communities, in the rural communities, in the migrant communities, etc. Climate change is a big risk in Latin America. a big part of Latin America is by the coast, not just the Caribbean, but also in South America. So the effects of climate change can generate big migrations, and that can affect the populations in terms of human rights. So advisory opinions by the Inter-American Human Rights Court
encuentro dentro de las preguntas sometidas 7 enfoques
has 7 clear approaches that I want to explain. And in the first place, as I said, to take into account that the impact is different depending on the place, on the populations. So there have to be specific obligations. And we need to focus on these groups like indigenous people, for example, rural areas, fishing areas, also women and children. So there are these specific obligations, specific needs. In second place, the importance of having the right to access information in terms of climate. The link between the regional agreement and the Inter-American human rights system. That is also a very important point.
Esta pregunta promete vincular este avance dado en
So there is this commitment to contemplate this link. In the third place, we have the future generations, how we must guarantee, how the states must guarantee the future for the coming generations. Then this is very important because it's the first resolution that mentions this. And it is a key point. Another point is the importance of legal resources, the right to legal aid, and the right of the communities to have a consultation that includes climate aspects. And the consultation as a tool to guarantee the good environmental conditions. The consultation also needs to assess global impact, not just regional impact. And I think this is an important change. And also, international cooperation is another one of the important aspects in relation to climate. And finally, I would like to say that there is another precedent in Latin America, which is a resolution in November 2017. For me, the important thing is to see what the focus will be in this advisory opinion. And just quickly, migration, climate migration, I think it's one of the very important aspects, and we will really need to talk about that, and it will need to be included in the advisory opinion. Then also the varied impacts. And I also want to mention the energy transition as a very important subject. For example, in Latin America, there is lithium is a very important metal that has the sourcing of lithium is affecting the local communities, and I think this should also be contemplated in the advisory opinion. And finally, I want to remind the importance of the future generations and how important it is that this is mentioned. Thank you, Digno, and congratulations to Chile and Colombia. We are estamos esperando.
And so these can be seen as working very much in parallel and co-supportive. I'd like to move now to a colleague, Nicole Ponce, who is the front convener for Asia of the World's Youth for Climate Justice. Nicole, you heard the Honorable Minister Regenvanu talk about how this initiative originated from students in the Pacific Island and is very much geared towards outcomes for future generations. So from a climate justice perspective, why is this question to the International Court of Justice so important for young people? How does this initiative begin to address what I think you all have been demanding so clearly for so long? Over to you, Nicole.
Thank you so much, Christopher, and thank you for inviting me and raising the voice of youth in this very crucial and relevant conversation. So, as you said, I would just like first to commend and acknowledge my colleagues, in fact, my friends from the Pacific, who are courageous youth leaders and have put the climate crisis on the global political agenda. So this is crucial for us because, again, we want to emphasize how human rights can play and must play a part of the solution in addressing climate change. So our aim in the World's Youth for Climate Justice is to contribute to integrating a human rights-based approach into the climate change discussions. So growing up in the Philippines, it wasn't easy for me to grasp the concept of climate change. But every year I see rise in our sea levels, the destruction of our crops due to natural, or I dare say human-caused disaster. And I witness how every year our mountains were transformed into mines and our forests were being cut and wiped out. In fact, in the case of Oposa versus Factoran, otherwise known as the children's case for us, the claimants argued that the logging concessions in the Philippines would wipe out old growth forests and that in 10 years, there will be nothing left for them and for future generations. So this is how the landmark case of Oposa versus Factoran gave life to the principle of intergenerational responsibility in the Philippines. So as a young lawyer myself, in law school, we were taught two basic things: that first, the state cannot be sued, and second, it's basic that children acting on their own and on the crazy claim of acting for future generation had no legal personality in the court of law. So this question to the International Court of Justice, as the principal judicial organ of the United Nations, or as we like to say or call the world's highest court, is in fact the proper forum to endorse the principle of intergenerational equity, as hopefully as an customary international law, and connect it to state obligations to protect the rights of the current and future generations from the adverse effect of climate change. So again, this is important because I really think we've always struggled to effectively communicate the real meaning of human-caused climate change. But just recently in my hometown, for example, we were struck by a super typhoon. Now in the Philippines, this is nothing new. We get an average of 20 typhoons in a year. But what we didn't expect was for this one to destabilize a whole city. This was not a remote island in the coastal or mountainous area, but a highly urbanized city. So in the aftermath of that typhoon, a whole city had no electricity, no drinking water, no utility water, phones were useless, and lines to buy food and gas spanned kilometers. It looked like something out of an apocalyptic movie, except it wasn't a movie, it's real life and we were living it. And what really stayed with me throughout this experience was the disparity of responses to the disaster. So the rich were able to buy generators off the bat and had them shipped from neighboring provinces, while the poor and marginalized had no electricity and or water for months. So vulnerable and marginalized sectors bear the brunt of the consequences and the adverse effects of climate change. So for us in the World's Youth for Climate Justice, this campaign for an advisory opinion is also a campaign for homes and our lives. And that's why it's a very important avenue for that nexus between climate change and human rights, which has not been, we're still not putting it forward in the discussion in terms of climate negotiations and things like that. And so we are hoping that with the advisory opinion with the ICJ, we could finally concretize that and cement that nexus between climate change and human rights.
Thank you, Nicole, for painting such a clear picture of where youth and young people are coming from. Maybe as a follow-up question, could I ask, what are your thoughts on upcoming climate litigation? We've heard a lot about youth-driven cases. How do you think this ICJ advisory opinion might enable or support those pathways?
Yeah, so we see that already in the case of Urgenda and Nebauer, as our experts and specialists have mentioned. So we see that national courts are increasingly comfortable with relying also on international climate change law obligations. So I think this will, and I believe that this will really influence national climate litigations and also assist our domestic courts in their efforts to develop a more consistent approach to the enforcement of environmental and international standards. And also, hopefully at that point, we are able to identify with the advisory opinion benchmarks to assess state actions. And this will give national courts tools to scrutinize such activities.
Well, thank you again, Nicole, and congratulations to you and the World's Youth for Climate Justice for inspiring states like Vanuatu to take up your cries, and we will continue to fight on your behalf with you alongside as long as we can. I might move now to our final panelist, Harjeet Singh, who is the head of global political strategy at Climate Action Network International, as well as the Global Engagement Director at the Fossil Fuel Treaty Initiative. Harjeet has been involved in the UNFCCC negotiations for a long time, and I know often very frustrated at the slow progress and minimal outcomes that we see, particularly for the most vulnerable. So in this context, Harjeet, how do you think this ICJ advisory opinion with such a strong focus on human rights might actually positively influence the outcomes of our international climate negotiations?
Thank you very much, Christopher. Thank you, ODI, for having me, and congratulations again to you, Vanuatu government, for your leadership on the ICJ campaign, and best wishes for the next steps. So as Nicole reminded us, and we are seeing the climate crisis in the form of unprecedented floods, storms, drought, and sea level rise, and many other climate impacts. And at the same time, we expect governments to come up with climate action plans so that we can still keep the hope of staying below 1.5 alive, at the same time deal with climate impacts through scaling up adaptation and also addressing loss and damage. But as Minister Regenvanu also pointed out, that these climate action plans, or what we call nationally determined contributions, are inadequate, and they have not been based on fair share. In fact, at the UNFCCC, in the form of Paris Agreement, what we got is a mechanism that is bottom-up. Now, in this case, bottom-up doesn't work. In this case, we need something top-down, which is based on equity, which is based on countries' responsibilities, based on their historical emissions and their capacities. And that has not happened. And if we look at the current state of ambition, it's going to take us way beyond 2.5 degrees Celsius. And imagine at 1.2 degrees, the level of impacts we are facing. We just cannot afford even a fraction in the increase of this impacts. And small island states are particularly vulnerable. So the first thing that ICJ can do, as we also discussed in case of litigation, is providing that legal clarity that advisory opinion can bring, which will pressure countries to improve their nationally determined contributions and not undermine Paris Agreement, but strengthen domestic policies and legislations, and particularly the human rights obligation. We need to acknowledge that what UNFCCC or Paris Agreement provides is a primary delivery vehicle to respond to the climate challenge, and also holding countries to account. And this is where we see ICJ as a complementary initiative that builds on the momentum of what we got at COP27 and UN other multilateral cooperation processes, as I said, to keep the momentum and make sure that 1.5 goal is alive and vulnerable countries get support. Now, Paris Agreement does acknowledge the obligation on human rights. It talks about right to health and rights of indigenous people, local communities, migrants, and so on. And the recent decision that we got at COP27, the Sharm el-Sheikh implementation plan, also included language on human rights. And it does talk about respecting, promoting, and considering the perspectives of and obligations on human rights. So what we need is pressure. What we need is more guidance. What we need is public pressure as well, so that the outcomes that come from COP28 can be strengthened. We can scale up adaptation and address loss and damage. And the way ICJ resolution aims to get clarity on the obligation of states, particularly towards present and future generations, and talking of legal consequences, I think this is extremely important to send a very strong message to the UNFCCC process, to Paris Agreement, that how important it is for us to scale up our action and update our climate action plans. And to me, and Christopher, I keep saying that we eventually would like to see advisory opinion be turned into a public opinion that makes this vehicle of UNFCCC and Paris Agreement really walk in that direction much faster than what it is right now.
Well, thank you, Harjeet, for again articulating, I think, what many around the world have been feeling and asking for a long time. And it's certainly the intention that this clarity will bring us forward. Please, all the participants, join me in giving a resounding thanks to our three panelists. I take away very much from this discussion that this advisory opinion at the ICJ and the advisory opinion in the Inter-American Court of Human Rights will be more than transformative. And it's an approach that I think we've been missing to date and will help us along. I can say with certainty that the government of Vanuatu and the core group of nations that have helped us develop the resolution for the General Assembly are very much coming at this from four key angles. The first of which is strengthening and upholding the rule of existing international law. We're, of course, very focused on protecting and promoting the human rights of all people everywhere. And of course, as we heard so eloquently from Nicole, ensuring that the rights of both present and future generations make it into these discussions. And finally, ensuring that our multilateral climate cooperation is more constructive and successful than it has been in the past. We must be able to implement the Paris Agreement as it was devised. So again, you can see the resolution up on vanuatuicj.com, and please join us as we take this long overdue step in the right direction and be on the right side of history. Thank you for civil society, for academia, and of course, all the state support that we've been seeing. And back to you, Emily.
Thanks very much. And a lot more to discuss as this initiative progresses. And I think, hopefully we can have more discussions later in the year when that vote is successful. We have one question in the Q&A. I think there was another question which Nadia has responded to. Thank you. And the question is about financial institutions. And I think this is another really important kind of leverage point. Is there a likelihood of asset managers, pension funds, asset owners, etc., being sued in climate litigations? How do we see that progressing, or how important is that going to be in the future? I'd like to ask James if you would be happy to take a stab at that question. Thank you.
Sure, Emily, I can certainly start, and others may want to chime in, but I think it's a critical question because we know financial institutions play a central role in financing some of the clear emissions activities which are contributing to climate change. And I think we are seeing some developments on that front, some very innovative kinds of legal action being taken, in addition to other kinds of advocacy, of course, which is building public pressure and focusing attention on the responsibility of financial institutions, and actually in some cases the individual directors of financial institutions, for the choices they're making with respect to their investments and financial activity. I mean, just a couple of examples. There have been, we've been involved in trying to make use of the law in France that establishes obligations for large corporations to effectively insure against risks all along their supply chains. By producing various reports and ultimately being held accountable for the risks that they have not adequately prepared for. And there's an open question at this point as to whether that due diligence procedure applies to banks and other financial institutions, and a number of groups, including ours, are trying to persuade the courts that it does. There are, of course, other there's analogous legislation developing in other European states and at the EU level, and the question of whether financial institutions and to what extent will be covered, I think is critical to those discussions. There have also been efforts, of course, Client Earth and other brave and courageous organizations have taken actions in national proceedings in the UK and I believe elsewhere that have talked about the role of financial institutions. The Securities and Exchange Commission in the United States has been a focal point for some activity recently by groups that are alleging that banks in the United States are not complying with their duties to take account of the risks of climate change in the investments and loans that they're making. And of course, the SEC is developing additional rules for public comment shortly that may provide further opportunities to look at the responsibility of financial institutions. So those are a few of many examples, but I think generally the question is a critical one, and it's an area for groups like those on this call to explore more fully as we look at every possible avenue to address responsibility for climate change and how to reverse it. Thank you.
Thank you very much. And yeah, clearly many levels at which we can have this discussion and many examples to learn from. Before we're coming towards the end of the event, before we leave today, I'd like to give the floor to Rebecca Fabrizi, who is the UK's Small Island Developing States Envoy. She's also Deputy Director for the Americas and Head of the Caribbean and SIDS at the Department for Foreign, Commonwealth and Development Office, FCDO. ODI is grateful to FCDO for its support in setting up our Resilient Sustainable Islands initiative and its commitment to helping small island developing states access finance and achieve sustainable development in a changing climate. Rebecca, we're keen to hear more from the UK government perspective and your reflections on the event and the importance of these discussions for small island developing states. If you could provide some closing remarks. Thank you.
Thanks very much, Emily. Thanks for managing my very long job title as well. And thanks so much to ODI for the event. I think it was really interesting. You convened such a great range of interesting and really knowledgeable speakers. So I feel like I've really learned a lot over the last hour and a half. we place great importance on our work for SIDS. Small island developing states have this unique combination of climate and economic vulnerabilities that undermine their resilience and really, make everything more difficult. And we've got a track record of advocating for SIDS, and that's why we're supporting the RESI initiative for resilient and sustainable islands. We're working to drive international finance reform, including climate finance, to help SIDS to address their unique vulnerabilities and to support resilient green economies. We're looking forward to the UN SIDS Summit next year as a really important date in our calendar, and we really want this to be transformational and deliver change, focusing on addressing climate and economic risks, which are really existential, and we're really aware of that. So action needs to happen before it becomes too late. We've got 3 kind of guiding principles for SIDS: that they're important to the UK, that they're different from their peers, and that they are responsible for achieving change themselves. And we've really seen that they're ready to step up. We've been, obviously everything is difficult for SIDS, but their stories are very, very compelling. We've been engaging with Vanuatu and this process that they've taken on as well. Our strategic approach is to use policy engagement and programs as well to support sustainable economic diversification and to help improve climate and economic resilience. And we want also to showcase how the rules-based international system can deliver for SIDS and help to make those changes and adaptations and so on that they need. SIDS are obviously global leaders in climate action. We've just been talking about that, and have a vital role in pressuring big emitters to act. The UK is committed to working alongside SIDS and in partnership with them, and really to deliver on the promises of the Glasgow Climate Pact, and that includes action on climate finance, and it also includes addressing loss and damage. IPCC has said that global emissions have to halve by 2030 if we're going to get to net zero by the middle of the century, to maximise our chances of limiting global warming to 1.5 degrees. We recognise that current impacts of climate change are leading to loss and damage, and that these are likely to increase in frequency and severity. And we know that more needs to be done at the global level, at regional and local levels too, to help countries and communities avert and minimise and address those losses and damages. And I think it was Joy, speaking on behalf of youth, spoke in a very compelling way about the community impacts. The UK spent £2.4 billion in international climate finance from 2016 to 2020 on adaptation, including investment in areas that's relevant to loss and damage. We announced £5 million of funding for the Santiago network at COP27. And we're looking forward to the selection process for the host of that body concluding this year, so that it can start to deliver the technical assistance that's needed. And we have also secured one of the 24 seats on the transitional committee set up at COP27 to consider loss and damage funding arrangements, including the dedicated fund. So we're really keen to make sure the work of the committee delivers results for countries on the front line of climate change impacts. And that includes SIDS, which is of course my key area of interest. So thank you so much again for these panels and discussions that were really very interesting. Our international development strategy sets out the UK vision that SIDS are going to be more climate and economically resilient by 2030. And we look forward to working with the international community to drive action on these issues and others ahead of that UN SIDS summit next year, which we hope will be a pivotal occasion. Thank you. Thank you very much.
Thanks a lot, Rebecca. And I think you've set out really clearly some of the important things that are going to be happening this year. And it's really been a great discussion, and I've learned a huge amount in thinking about the role of law and the international legal system, and in advancing different aspects of the climate change agenda, and the importance of law as a policy instrument, and the very kind of critical role it can play. And I think we're going to see a lot more of that, and it sounds like there's lots of kind of promising initiatives, including the ICJ initiative led by Vanuatu. So again, great leadership from a small island. We are right at the end of the session, and we have covered a huge amount. I think each one of these conversations could have been a full event. So be very happy to continue discussing and to host further events this year. I want to thank very much all of our speakers for being here, joining us from around the world in different time zones. And thank you to everyone who has logged on to watch and engage with this important discussion. And I do hope to see all of you again soon, and to keep working on this very important issue. Thank you very much.